Any mention?
Yes, my lord, I beg to mention item number 11, my lord. My lord,
Yes.
remembers this was that matter, my lord, where legal aid was there, then withdrawn, private, again legal aid. I have spoken to the family member and I have spoken through the jailer to the appellant also, my lord. He wishes to engage a legal aid counsel. And I have sent a wakalatnama also to be signed by him, my lord. So I'm yet to receive that wakalatnama according to
When do you want it? Then?
after 3 weeks, my lord.
Request made by on the request made by Mr. Sharma, London Legal Aid Counsel, preparing for the appellant. This is not after 3 weeks. When you are already there, is there any requirement of giving?
My lord, seeing the past
Personal-
experience,
personal capacity.
personal capacity, my lord.
What?
Deeply obeyed.
Please, Lordship. Lordship, item numbers 14 to 23, connected matters, my lord.
Yes.
If Lordship would kindly allow some time to prepare, 2 weeks may kindly be given, my lord. 14
No
to
problem.
23.
You are there also. Yes. According just requested by Mr. Jinda, London Counsel for the petition. Which chapter?
2 weeks, my lord.
Problem.
Official.
May I please, Your Lordship? Your Lordship, I would beg to make a mention of item 12.
Yes.
Your Lordship, I pray that this matter can be adjourned for today. I can pray for 3 weeks' time.
Yeah, at the request of the petitioner list after 3 weeks. Yes.
Oblige, Your Lordship.
Please, Your Lordship, I beg to make a mention of item number 5. Lordship. Lordship, I'm praying this matter may be listed after 3 weeks, Lordship.
Item 5.
Lordship.
Your Lordship, I am for the GHDC. I have no objection, Your Lordship.
5C at the request of the petitioner.
Your Lordship, I am appearing for respondent number 7.
Yes. As a request of the petitioner, not objected to by the London Council appearing for the respondents. List this matter after
3 weeks.
yes.
Lordship, similar prayer for item number 6, Lordship.
Who is respondent?
I'm there, Your Lordship. 6 and 7 are analogous, Your Lordship.
So both the matters will go.
6 is by Mr. Paul and 7 by Mr. Dindo, Your Lordship. I think they are here. Are they not?
Yes. Same prayer. Same order. Yes.
Oblige, Your Lord.
Lordship, similar prayer for item number 9, Lordship.
Your Lordship, I'm for responding 3 and 4.
Your Lordship, I am for the respondent number 1 and 2, Your Lordship.
This also same. You have no objection?
No objection.
No objection, Lordship.
Yes.
Highly obliged.
Highly obliged, Your Lordship.
Lordship, I beg to mention item number 8, Your Lordship, on behalf of the Advocate General.
Yes.
Item number 8, Your Lordship. I
Yes,
pray
well
for
done.
2 weeks' time, Your Lordship.
What's the matter about?
Lordship, it's a writ petition filed by the state against an order passed by us Lokayukta. As per the order, state was supposed to conduct investigation, etc., file charge sheet, etc. Against that order, state has come, my lord. If Lordship kindly recalls, there is a somewhat connected matter pending in the coordinate bench, courtroom number 3. So the question was, because of the change of roster, one matter has come to this honorable bench, while the other matter remains there, my lord. So our submission would have been today to try and convince that this matter can be taken independent of that matter. But if they're taking time,
When do you want it?
After 2 weeks, Your Lordship.
Okay, up to this. This also had the request meet on behalf of the Learned Advocate General applying for the petition of state. It's appearing for the petition. This is matter of 2 weeks. Yes.
Oblige, Your Lordship.
Daily causes, item number 1.
This is a matter,
Yes.
my lords, similar to another two matters, my lords, which are pending before your lordship.
But what
in
is
respect of Lokayukta and the proceedings which were initiated by the Lokayukta against private persons, and in respect of conduct of GHADC. So, my lords, in this case, again, there is a private person who has been subjected to proceedings before the Lokayukta. And, my lords, the conduct of the proceedings has been such that the entire procedure which has been prescribed under the Lokayukta Act has been given a go by. So, my lords, in this case, the situation is similar to the other matters, that there was a grant of 100 crores by the government of India way back in 2015.
other matters are pending before this court?
Yes, my lords. My lords, that is writ petition criminal number 2 of 2023.
Then 6 W.
Oh, achha, yes.
Yes, my lords. So,
Mr. Sangma is representing there.
yes, my lords. So, my lords, in this matter, what had happened is that similar to the other matters, there was a 100 crore grant which was made by the government of India to the GHADC for utilization for various schemes. About, my lords, 1200 contracts were awarded for various schemes. And there was a decision which was taken by the executive committee of the GHADC that because these projects have to be completed within 1 year, we will grant 60% of the advance. Thereafter, the contract was given to me. To the extent of the amounts advanced, I completed the work. And then in 2020, I wrote a letter to GHADC asking them that I am ready and willing to complete the remaining works. You issue the balance amount and allow me to complete the works. Nothing was done by the GHADC in respect of that letter. 1 year subsequent to that, and that is about 5 to 6 years after the project was awarded to me, a complaint has been initiated.
Was it not for you to complete the work and then claim the bill? Was it something like that?
No, that was not provided in the contract which was given to me, that the amounts will be paid after the works are completed. There are certain kinds of contract where you pay certain amount of advance and then the contract is executed.
Normally in contract work it is always like that, you complete and you finish. After once you submit your bill, then it gets cleared after necessary inspection and all.
Yes, my lords, that is there in certain amount of contract, but that is not the dispute herein. The proceedings which began in 2021 began against me and other certain contractors as well as certain officials of the GHADC. And in that, my lords, the Lokayukta Act says that it has powers against public functionaries. Power against public functionaries, and if your lordship is very well aware that the Lokayukta was created as a body for the purposes of checking corruption done by officials of the state government. So the Lokayukta under section 20 of the Act is required to first check whether it can proceed with the matter or not. That, my lords, was never done. As soon as the complaint is filed, the Lokayukta proceeds with a preliminary inquiry. Preliminary inquiry as per the Act has to be conducted.
What happens when a complaint is filed against you? You are given notice before Lokayukta proceeds further?
Yes, my lords.
You were given notice after a complaint was filed against you.
My lords, notice is given, and we also, in the course of the proceedings, we approach the court with an application that you do not have jurisdiction over us. That was rejected by saying that I cannot decide whether I have jurisdiction or not. That can only be done by the special court.
You raised the plea of jurisdiction before the Lokayukta.
Lokayukta itself.
But then that you did not challenge before any other authority. You did not make any challenge before any other authority.
Because yes, that was not challenged.
Just tell us the fact.
Yes, yes, that was not challenged.
You give us later.
Yes, yes.
This court is trying to get the fact.
Yes, yes. Because that was not challenged, but that happened pretty. The order is 14/3/2024, which has been passed, and thereafter the Lokayukta said that we will take a call at a later stage. That was, we were never intimated about any subsequent proceedings which were going to happen before the Lokayukta. But be that as it may, my lords, the second limb of the Lokayukta is to conduct a preliminary inquiry once it's received a complaint. As far as the preliminary inquiry is concerned, the Act says that you have to have an inquiry wing where there are officers above or at the rank of under secretary in the government. If you do not have an inquiry wing, then ask the government to conduct an inquiry. What does the Lokayukta does? It has an inquiry wing headed by a retired officer, and it conducts an inquiry virtually by a private person.
Why you are saying that?
Well, it's because the Act says that it has to be an officer serving in the government of the rank of under secretary.
Who will be heading the wing?
Not heading the wing, any officer of the inquiry wing should be a public servant.
So the inquiry wing would consist of how many officials?
That is not described in the Act.
So it can be one person.
It can be one person. My grievance is not with the number of persons that are there in the inquiry wing.
What is the legal requirement for it? So if you challenge the legality of the inquiry, then we must know it.
Yes, the requirement is that it has to be a serving officer of the government. It cannot be a retired officer who has retired from the government service. So a retired imagine a situation, Velox, if we compare this with any other criminal proceedings, the inquiry is done by a police officer who's a public servant. Now here you are giving all those powers, I don't know what permits the Lokayukta to do that act, to a person who is a retired officer. That is not permissible under the Act, under Section 11 of the Act. Based upon the inquiry report, the Lokayukta has to make a prima facie view that whether the allegations are made out or not. The inquiry report doesn't say anything. The Lokayukta in its order says nothing that there is a prima facie case against me, and proceeds ahead and requests the Director General of Police to appoint some officer for further investigation. The investigation has to be completed within a period of 6 months. 2 years are taken, multiple extensions are taken, and the Act requires that you have to give a reason for that extension. No reasons are given. After a certain period of time, even the extensions stop. There is no extension order, and then a charge sheet is filed. Charge sheet is dated 4th August 2024. Filed before the District and Session Judge on 4th August 2024. Matter comes before the Lokayukta on 4th September 2024. Ideally, the Lokayukta, the Act says that the investigation report has to be submitted by the Lokayukta. The Lokayukta will apply his mind whether the case has to be remitted to the special court or not, or what actions are to be taken against the public officer. Nothing of that. Everything is fait accompli. So 1 month prior,
unless Lokayukta expresses its mind, the court cannot take cognizance.
Yes. So my lords, what happens is before taking cognizance of the investigation report, that investigation report is already submitted to the District and Session Judge. And then a mechanical hearing, it's not a hearing, my lords, that report is submitted, no one is heard. And thereafter the Lokayukta directs the Director of Inquiry and Prosecution to remit all case records to the public prosecutor and initiate the proceedings before the special court Tora. So, my lords, in the entire scheme of things, there are various checks and balances where the Lokayukta has to apply his mind and see whether a case is made out for further inquiry, further investigation, or remitting the case to the special court. Nowhere the Lokayukta applies his mind. When I move an application before the Lokayukta saying that you do not have jurisdiction, he says that I cannot decide whether I have jurisdiction or not. That can be only decided by the special court, which is absolutely incorrect, my lords, because what I did, my lords, well, these matters are pending before your lordship, and this act is, my lords, paramateria with the act of the Lokpal. This act came in 2014. I analyzed, my lords, personally I analyzed the various orders passed by the Lokayukta. Detailed orders are passed At the stage of preliminary inquiry, the inquiry is sent to the CVC. The CVC sends it to the CBI. The report comes. Thereafter, the Lokpal analyzes whether a prima facie case is made out, asks for registration of a case if it is made out, and then further investigation is done. Nowhere, my lords, the entire procedure which has been followed by the Lokayukta has been in complete contravention of the Act. And thereafter, my lords, what the story doesn't end here. The thing is that the prosecution has to be conducted by the Director of Prosecution of the Lokpal. Today, the prosecution is being done by the public prosecutor before the special court. The special court has to be constituted as per section 36 of the Lokayukta Act. There is no notification for constitution of a special court. My lords, so there is a complete non-compliance of the Act while proceeding with these matters.
According to you, nothing is correct about this.
Yes, my lords.
Everything is wrong.
My lords, almost everything is wrong.
And so far your submission, it transpires that.
Yes, my lords.
Yes, Mr. Sulai.
Lordship, let us be assured that the issues raised be examined, Your Lordship. Because a private respondent also is here. Lordship.
No, private respondent will enter appearance to him.
Yes, I was asking.
Yes. And what you will say? What about say with Mr. Pandey's contention?
Lordship, I've been finding even the maintainability of this petition. Now, before I go by, I make a small submission. Now, the hearing case, my learned friend, he has not specified the exact, the core matter, the case, the real track of the case. What is happening here is, so yes, generally.
See, Mr. One thing, Mr. Sarma. See that all his pleas raised are all concerning question of law. Do not go. Let us not go to the facts and the facts of the allegation. What is happening? We will not definitely not go into the merits and demerits of the allegation. Just talk about things which the question of legality is by Mr. Pandey. Legality and correctness of the proceedings.
Before I come to that, just want to highlight.
You can sit down, Mr. Pandey.
I definitely I will answer whatever.
No, what is your challenge to maintainability?
Here that 6 crore amount was the project was.
Do not come to that.
Yes, Lord.
Forget about this. We will come to those.
Yes, I will come to that.
Why you are talking about the
one
value?
of the thing is that he's saying that the retired officer have no power to investigate.
Yes.
But interestingly, the investigation officer was appointed purely by the government with all the following all the due procedures.
But then does it fulfill the requirement of law?
Definitely,
See, you have to give us all those things, and then now just tell us what is first thing first. You tell us why you are challenging maintainability. You said that you will challenge the maintainability of this rate.
Because earlier occasion he has filed an application to strike out her name from the complainant from making as a necessary party. Because the complainant, actually I am the private respondent, I have filed a complaint case.
At earlier what stage? Which stage? And where it was filed?
It was filed before the Lokayukta.
So
it was
now his request for striking out his name was rejected.
It was rejected by the court.
So, but then just because of that writ petition will not be maintainable.
No. Once I get, because I have not received the detail also, but I just heard from whatever.
You file your affidavit, will issue notice. Heard, Mr. Pandey.
So just one request, at par with the other matter, my lords, I am requesting that the matter, the nature, these proceedings may be stayed before the special.
Proceeding is going on. What is the stage of the proceeding now?
My lords, it is for fixation of charge. Tomorrow, my lords, it is listed.
My lords, this is a different case, my lord.
Yes, Mr. Sulai, what is your
Lordship,
so far as the interim prayer is concerned?
The issue raised appears, Lordship, is similar to the earlier writ petition.
So you will not object to the prayer of stay?
Lordship, I may be allowed to file in my objection.
You will file it. You will file. Definitely, you will file it. You file it, Mr. Sangma. But then at least give us some answer. We do not know whether what Mr. Pandey has said is correct or not. But then we need to adjudicate all those.
Yes, that's why Your Lordship, at this juncture, Your Lordship, that the interim may not be important because it is a different case, Your Lordship. Different case. It's based,
no, but then until and unless you answer to his legal points, then what is the question? Anyway, we'll just see it. Heard, Mr. Pandey, Learned Counsel. appearing for the petitioner. It is in the writ petition. Issue notice, returnable in 3 weeks. Mr. Andy Shulai, along with MSR Corney, appears for the respondent number 1. Mr. P.T. Sangma enters appears for view of the respondent number 2 and has no formal notice is required to be issued. When you will be filing your thing?
After 2 weeks, my lord.
You will supply him copy or you have already supplied?
We will do that today.
The petitioner shall supply a copy of this petition to the learned counsel for the respondent number 2. This is matter after 3 weeks.
Lordship.
Then come to the Miss case. Say by this application, the applicant has paid for stay of proceedings of special PC case number 2 of 2024 pending in the court of. Is it before special judge?
Yes, special judge.
Special judge. West Garo Hills, Tura. Give a stop, give paragraph. Mr. Pandya, learned counsel for the applicant, has questioned the legality and validity of the entire proceeding initiated against the applicant before the Lakayakta as well as before the learned special judge. He submits that the requirement of law as prescribed in the statute has not been followed when this entire matter proceeded against the applicant, which has resulted in filing of charge sheet against him. He submits that if the proceeding is allowed to continue, the applicant will be highly prejudiced and prays for stay of the proceeding till the final disposal of the main writ petition. Stop. Give a paragraph. So you are not been able to say anything right now. Anyway, shall we say you do not have any serious objection?
Lordship, my submission is that since that it's a legal issues that needs to be examined, Your Lordship.
See, the next paragraph is learned AG appearing for the state submits that without necessary instruction he is not in a position to make the stand of the state clear before this court at this stage. Stop. Mr. P.T. Sangman, learned counsel, appearing for the respondent number 2, also prays for grant of some time for taking necessary instruction. Stop. Give a paragraph. Since the question of legality and correctness of the entire proceeding has been raised, and in absence of proper availability of proper response from the respondents at this stage, it is deemed appropriate to order suspension of the proceeding of such and such case at the beginning. What you said, till the returnable date. We are passing till the returnable date. Let us see what objection you bring. If you bring strong objection, we will reject his case. We will dismiss it then.
Yes.
Oblige, Your Lordship.
Item number 2.
List along with the main case.
Yes.
Hearing item number 10.
My lord, we have some difficulty, my lord. If this matter can come off after a week or maybe tomorrow, my lord. Why tomorrow? Why, what is the difficulty? What is the matter about?
This is a criminal charge with regard to section 354 and 509. The case about a gender neutral.
This was pending before this court only?
Yes, yes.
So it's paying for 1 week's time?
As you.
Mr. Argurum, learned GA appearing for the respondent. Praise for grant of some time to prepare the matter. Stop. The learned senior counsel appearing for the petitioner has no objection. Clear alert, list after a week.
Man. Watch me.
Item number 13.
Lordship, I'm appearing on behalf of Mr. S. Thapa. He's still on legs, Lordship. Lordship, we have it at the end of the board. No objection, Lordship.
No objection? What for?
For having it at the end of the board.
For having the matter when?
End of the
It will go as a joint prayer. It will go as a joint prayer.
Yes, Your Lordship.
You want it to go as a joint prayer?
Yes, Your
There is an interim order here.
Yes, Your Lordship.
Okay. At the joint prayer.
Lordship.
Yes. Yes.
Look, they filed a revision against an order passed by the trial court under 39(2)(a). My lord, there are two things here, my lord. The application which they have filed is defective. Inasmuch as, my lord, may kindly see the synopsis first. What it appears from the synopsis is, my lord, this revision is filed under 227.
Now, you obtained the injunction.
I obtained the
from the trial court.
My lord, there was a status quo order.
What they are challenging, ex parte interim order?
No, my lord. There was an order, status quo order initially from the trial court, my lord, in my favor.
You are the plaintiff.
I was the plaintiff in the trial court. Now, my lord, status quo was issued. My lord, subsequently it was made absolute, and the condition precedent was it was made absolute till the disposal of the main suit. Now, what has happened, my lord? In the meantime, my lord, there was a status quo. I'll just take your lordship from from the
why
beginning.
this 227 revision? If it is something related to injunction,
correct, ma. This order, the order which they are, it is an appealable.
So why revision under 227?
I do not know, my lord, why they have filed it under 227.
So that is what that is.
It is an appealable order. Besides that, my lord, this application is time barred.
They have not approached the appellate authority, isn't
No,
it?
no, no.
From trial court directly before.
My lord, it is basically to bypass the limitation, my lord, to overcome the limitation.
So that is one of the aspects.
One of the
Second thing
aspects.
is that then say supposing if revision is barred, this is normal law. If law provides remedy of appeal, revision is barred. That is what 115 would say, isn't it? So definitely in normal situation you cannot bypass. 227 cannot be, you see, invoked as a regular procedure. It is
Correct.
only in the rarest of rare.
Even if a decision is a wrong decision, my lord,
This cannot be
227
done.
will not lie.
Yes.
You have to show that there is an absolute perversity on the part of the court, or the court exceeded jurisdiction.
227 is basically power of superintendence.
Correct, my lord.
If trial court goes beyond the limits of law, then only 227 can.
Correct.
Otherwise,
correct, my lord. Here,
constitutional provision are not to be invoked on regular basis, isn't it?
absolutely, I bow
That
down.
is why. So what is to be done?
Lordship, learned DSJ is on legs before courtroom number 3.
That if you pray, then we'll adjourn it. When do you want it?
Lordship, after 2 weeks.
After
2 weeks.
after 2 weeks. So let's wait for why. The learned counsel. Let's wait for on behalf of Dr. Majika. Learned counsel appearing for the petitioner. At least this matter after 2 weeks. There's an interim order.
Yes, Your
There
Lordship.
is one.
So what is to be done?
Pray that the
Well,
interim
I
order will
would
continue.
oppose the internal, but the situation
order.
is such.
It's a problem, you know. You should be, before you appear, you should be equipped, you see. This court is not there to protect your welfare. You should protect yourself. The interim order passed earlier shall continue. Oh, that is already there until further order. It's not required. It's until further order. Yes.